Hello everyone, I am Dipender Singh, Assistant Professor, Tripoli, NATE, Maharaja Agar Singh University, Baddi, Solan, Himachal Pradesh. Today we will discuss about intellectual property, patents, their copyrights, trade secrets. Intellectual property is a category of property that includes intangible creations of the human intellect and primarily comprises of patents, copyrights, and trademarks. It also includes other types of rights, such as trade secrets, publicity rights, moral rights, and rights against unfair competition. Intellectual property refers to an invention, idea, design, literary and artistic work, symbol name, images, etc. that a human being has created and the law prevents other people from copying. What are patents? A patent grants property rights, legal grant, or license on an invention, allowing the inventor to exclude others from making, selling, or using the invention. Inventions allow businesses to be more successful because they develop newer and better products or processes that offer competitive advantage over the market. Three types of patents: utility patent, design patent, and plant patent. A utility patent covers any process, machine, article of manufacture, composition of matter, or any new and useful improvements thereof. To qualify for a utility patent, our invention must be novel, non-obvious, and have some usefulness. Novel means new and not known by anyone else, and non-obvious means that it can't be immediately obvious to someone with ordinary skills in that domain. A utility patent lasts for 20 years. However, periodic fees are required to maintain the enforceability of the patent. A design patent covers any new original or ornamental design of an article of manufacture. A design patent lasts for 14 years. A plant patent covers any new variety of asexually produced plant. A plant patent lasts for 20 years. A utility patent covers any process, machine, article of manufacture, composition of matter, or new or useful improvements thereof. Now, what about the patent protection? With patent protection, the patent holder can take legal action against anyone who copies the patented invention, design, or discovery. However, without such legal protection, anyone can use similar design, products, and processes without risk. In fact, if one doesn't file for a patent protection on one's invention within 4 months of releasing it in a public setting, the opportunity of patenting it will be gone, as someone else may patent it. What is the process of patenting and development? Patent Rules 2003, as amended by the Amendment Rules 2006. Some basic requirements were novelty, uniqueness, unpublished filing application for patent. Any person, any person may apply for a patent either alone or jointly with any other person, inventor or his assignee or legal representative in case of ordinary application or in the case of priority application, the applicant in the convention country or his assignee or legal representative. A corporate body can't be named as inventor, foreigners, and nationals or not living in India. need an address for service in India or may appoint a registered agent representative whose address can be the address for service in India. Now, what about the place for filing? An application for patent must be filed at Patent Office branch within whose territorial jurisdiction the applicant resides or has his principal place of business and domicile. A foreign applicant must file in the Patent Office branch having jurisdiction over the place where his address for service is located. Priority. What is the priority? It can be claimed from the earliest corresponding application in a convention country, provided that the Indian application is filed within 12 months of the priority date. Multiple and partial priorities are allowed. Specification for process of patent and development. A priority application must be filled with complete specifications. The first instance, but a non-priority application may be filled with either provisional specs or complete specs. Where provisional specs are filled in the first instance, complete specs must be filled within 12 months. Where 2 by 3 or more provisional specs have been filed, may be cognated and all the subject matter may be incorporated into a single complete specification to be lodged within 12 months of date of the earliest filed provisional specification. Naming of inventors. For non-priority application, inventors must be named in the application form. For priority applications, a declaration as to inventorship must be filed with the application of within a max period of 6 months. Information of corresponding applications in other countries necessary at the time of filing a patent application in India to inform controller of the details of all corresponding applications in other countries and to undertake the keep of controller so informed up to the grant of the Indian application. Failure to do so could result in the refusal of application in case it is opposed or even revocation of a patent in proceedings before High Court. Patent examination. Both formal and substantial examinations are made by Indian Patent Office. Examination is by request. What is the procedure? Applicant is required to meet all objections and requirements of Patent Office within a period of 12 months from the date of the first examination report, called as FER, issued by the controller. No extension of time is permitted. If a patent application is not put in order in 12 months from the date of the FER, it lapses. What about the amendment of application? Applicant may, of his own accord, apply to controller for amendment of his application or any document filed in respect thereof, but such amendments must be filed by way of correction, explanation, or disclaimer. An applicant may also amend his application or specification at the instance of examiner and file separate divisional applications for the other invention, which will be accorded the date of filing of the complete specification of the original application or such later date as the controller may fix. The divisional application must be filed prior to the grant of the parent publication. Patent publication. It takes 18 months from the date of application. Urgent publication possible on request for payment of fee. On and from date of publication of application for patent and until date of grant of patent. Such application applicant will have like privilege of rights as if a patent for the invention had been granted on the date of publication of the application. Pre-grant opposition of patent application after publication, but before the date of grant, by way of representation, anyone may file opposition to the grant of a patent. Publication of subject matter grant of application is published in the official journal and notified therein for post-grant opposition. A patent can be revoked within 1 year after grant by post-grant opposition proceedings before the controller of patent. Revocation of a patent possible on the grounds of prior publication anywhere in the world, public use or knowledge in India, lack of novelty with regard to subject matter, obviousness, lack of insensitiveness, ambiguity, insufficiency of description of invention, fraud, false suggestion, or representation that the person named as inventor is not the true inventor, lack of utility, non-patentability of subject matter, example, food, drug, or medicine, atomic energy, mere admixture, mere arrangement of known devices, process of testing, method of agriculture or horticulture, process of medicinal treatment, failure to furnish, or falsity in material particulars of information regarding corresponding applications in other countries supplied to controller, or that the invention is contrary to law and morality. Annuities, except in the case of a patent of addition, for which no amenities are payable, annual renewal fees be paid during the life of an Indian patent. The first of such fees falling due at the end of the second year of the life of a patent granted. Renewal fees falling due during the pendency of the application are payable within a non-extendable period of 3 months from date to patent is taken record in the register of patents. For more years, renewal fees may be paid in advance if patentee so desires. A maximum extension of 6 months may be obtained on payment of prescribed penalty fee. If the renewal fees is not paid within the extended period available, the patent will lapse. A lapsed patent may be restored by an application for restoration in made within 1 year of the date of lapsing of the patent, provided it can be shown that the lapsing of the patent was unintentional and that there was no undue delay in making the application for restoration. Working of patents. Every patentee and every licensee is required to furnish within 3 months from the end of the calendar in which the patent is granted a statement as to the extent to which the invention has been worked in India on a commercial scale in the preceding year. Non-filing of the statement is a criminal offense. Compulsory license is required. After 3 years from the date of filing of a patent, an interested party may apply to the controller for the grant of a compulsory license, alleging that the reasonable requirements of the public with respect to the invention have not been satisfied or that the invention restoration. A lapsed patent may be restored if application for restoration is made within 1 year of date of lapsing of the patent, provided it can be shown that the lapsing of the patent was unintentional and that there was no undue delay in making the application for restoration. Working of patents. Every patentee and every licensee is required to furnish within 3 months from the end of the calendar year in which patent is granted. A patent has to the extent to which the invention has been worked in India on a commercial scale in the preceding year. Non-filing of this statement is a criminal offense. Compulsory licenses after 3 years from date of filing of a patent are interested party may apply to controller for grant of a compulsory license alleging that the reasonable requirements of the public may respect to the invention have not been satisfied or that the invention is not available at reasonable price. If controller is satisfied that a primary specie case for applicant for compulsory license has been made out, he shall serve notice on the patentees who, if they so desire, may oppose the application for compulsory license. Not compulsory, but it advisable as otherwise damages may be difficult to recover in cases of infringement. The invention may be marked with the word patented or patent, accompanied by the number and year of the patent. Infringement suit may be instituted by a patentee, his exclusive licensee. Every ground for revocation is available as a defense, and revocation can be counterclaimed in infringement proceedings. Court may grant relief in respect of a valid claim or claims even through one or more other claims in the suit may be held to be invalid. Relief may include damages and cost as awarded by the court. A suit for injunction may be instituted and damages recovered in cases where there have been groundless threats. Any person may institute a suit for declaration as to non-infringement of a patent. Onus to proof of non-infringement lies in the defendant. Patents and computer software. It is possible to patent programs for computers which when run on a computer produce a technical effect or includes hardware. If a program doesn't produce technical effect when run on a computer, it is not patentable. Technical effect is generally an improvement in technology and needs to be in an area of technology, which is patentable. Example, an improved program for translating between Japanese and English isn't patentable as linguistics is a mental process, not a technical field. Some countries such as USA may be potential market for somewhere have a more liberal approach to patenting and often grant patents for software, which will be excluded in India and other countries. Deciding whether or not a particular computer program is patentable is a complex issue, and advice from a patent agent may help determine which is the most effective form of protection available. Patent Cooperation Treaty, known as PCT. It helps applicants in seeking patent protection internationally for their inventions, helps patent offices with the patent granting decisions, and facilitates public access to a wealth of tech info relating to those inventions. It is a patent filing system and be not mistaken for patent granting system. Thus, no PCT patent or international patent is granted. The task and responsibility of granting patents remains exclusively in the hands of the patent offices of the countries where patent protection is sought. IPR of biological systems. Years of research on biological systems need to be compensated. The system is self-sustaining. If patents are granted, companies will request time in research, and if not, there will be less incentive for companies to do research. The ethical principle of beneficence can also be applied. Thus, commercialization of biotechnology lead to more benefits than a bar on it. The benefits should be in terms of general medical or agricultural developments rather than economical prosperity or of one company or country or the other. Now, speaking about the trademark, a trademark is a word, phrase, symbol, or design that distinguishes the source of products or services of one business from its competitors. In order to qualify for trademark protection, the mark must be indistinctive. Example, the Nike swoosh design identifies athletic footwear made by Nike. Before registering a trademark, one must be conduct a thorough search of databases to make sure that a similar trademark is not already registered. Trademarks expire after 10 years and the renewal terms are 10 years. What is copyright? It protects original works of authorship such as literary works, music, dramatic works, pantomimes, choreographic works, sculptural, pictorial, and graphic works, sound recordings, artistic works, architectural works, and computer software. With copyright protection, the holder has the exclusive rights to modify, distribute, perform, create, display, and copy the work. Copyright protection lasts for 70 years after the death of the author. For works made for hire, the copyright lasts for 95 years from the year of its first publication and a term of 120 years from the year of its creation, whichever expires first. Trade secret. Now, a trade secret is a formula, process, device, or other business information that companies keep private to give them a business and advantage over their competitors. Example, soda formulas, customer lists, survey results, computer algorithms. Unlike other types of IPs, one can't be obtained protection by registering one's trade secret. Instead, it lasts as long as one takes the necessary steps to control disclosure and use of the information. A trade secret can protect it indefinitely as long as the secret is commercially valuable. Its value derives from the fact that it is a secret, and the owner takes reasonable precautions to maintain its secrecy. Businesses use non-disclosure agreements, restricted access to confidential info, post-employment restrictive covenants, and other security practices to maintain trade secrets. Thank you. You can ask any question in the comment section. Hope you have understand the patents, copyrights, trademarks, trade secrets topic very sincerely. Thank you all.